Welcome back. And we now going to start our panel B, which is the last panel discussion of today's conference. Panel B will be moderated by Professor Ling Feng, and Professor Ling is Associate Dean at the School of Law of City University of Hong Kong. And Professor Ling is also Director of the Center for Judicial Education and Research at City University of Hong Kong. The session is yours, Professor Ling.
Okay, thank you, Guan. I would like to thank the organizer to give me the honor to chair this distinguished panel. We have three papers and four, I understand, participants here. So the first speaker will be Professor Jan Lieder from University of Freiburg, Germany. So the floor is yours. Thanks.
All right, thank you so much. Dear colleagues, ladies and gentlemen, it's a pleasure and an honor to be here and do the presentation. First of all, I will share my screen. How does that look for you? All right, very good. Yes. Thank you so much. So it's a great to have the opportunity to talk about the changes that artificial intelligence brings about in corporate law, about challenges for corporations and their executives. And I'm afraid I think I have to disagree on one point with Dr. Tang, but later. On this slide, you can see the roadmap for the following 50 minutes. After a short introduction, I will ask whether algorithms could and should act as directors of corporations. Thereafter, I will address the use of AI applications by human board of directors, including the legal framework, AI-related duties, and the business judgment rule as a safe harbor in terms of manager liability. In the end, I'm going to conclude. By referring to AI, I mean information technology systems that reproduce or approximate various cognitive abilities of humans. In the same breath, we need to distinguish between strong AI and weak AI. Currently, there's no strong AI. There's no system that really imitates a human being, such as a super intelligence. Only weak AI is applied today that are single technologies for smart human-machine interactions, such as machine learning or deep learning. By referring to corporate governance, I mean a system by which companies are directed and controlled. In continental European jurisdictions, just like Germany, a dual board structure is the dominant system, with a management board running the day-by-day business of the firm and a supervisory board monitoring the business decisions of the management board. In Anglo-American jurisdictions, just like the US, UK, Australia, the two functions of management and supervision are combined within a unitary board, the board of directors. The first question is, could and should act algorithms as directors? In 2014, newspapers reported that a venture capital firm just appointed an algorithm to its board of directors. The Hong Kong-based VC firm, Deep Knowledge Ventures, should have appointed an algorithm called Vital. This is possible under Hong Kong law, I believe. This jurisdiction only requires one human being on the board. In fact, Vital only had an observer and advisor status with regard to the board members, which are all natural persons. And when I say had, I allude to the fact that Vital was fired in 2019. Under German law, the members of the management board and the supervisory board must all be natural persons with full legal capacity. Not even corporations are allowed to serve as board members. So in order to appoint algorithms as directors, the law must be changed Actually, the lawmaker could legally recognize e-persons as directors, as Dr. Tang has pointed out. However, I think that would not be such a brilliant idea, because there is a reason for the exclusion of legal persons and algorithms, at least under German law. Both lack personal liability and personal accountability for the management and the supervision of the company. As long as there are no strong AI applications, no super intelligence, a machine simulation of a human being cannot replace actual human behavior. True, circumstances may change in the future due to technological progress. However, there is a long and winding road to the notorious super intelligence. Nevertheless, the European Parliament enacted a resolution with recommendations on the Commission on Civil Law Rules on Robotics. The Parliament suggested, and I'm quoting now, creating a specific legal status for robots in the long run, so that at least the most sophisticated autonomous robots could be established as having the status of electronic persons responsible for making good any damage they may cause. End quote. The most fundamental requirement for legally recognizing an e-person would be its own liability, either based on an ownership fund or based on a mandatory liability insurance. However, even if we would establish such a liability safeguard, there is no self-interested action of an algorithm as long as there is no strong AI. Weak AI does only carry out actions in a third-party interest of people or organizations. In the end, current algorithms are nothing more than digital slaves, but slaves with superhuman abilities. That means we are stuck with human directors for the next several decades. Under German law, those human directors on the management board shall be directly responsible for running the company. Consequently, the management board does also decide on the overall corporate strategy, the degree of digitization, and the use of AI applications. The supervisory board decides on the approval on particularly important measures and on the appointment of the management board members, whereas shareholders in the German stock corporation does not have any say on the company's digitization structure at all. At the moment, examples that are discussed most for the use of AI applications are high-frequency trading, installment lending by banks, as well as cybersecurity and compliance management systems. With regard to those use cases, the management board must have a fundamental understanding of the relevant AI application, of their potentials and their risks. The board may delegate the responsibility for applying AI to subordinate employees, but it is required to carefully select, instruct, and supervise the delegate. However, core tasks cannot be delegated at all, as board members are not allowed to escape from their leadership responsibility. Only the preparation of decisions by auxiliary persons is permissible, as long as the board of directors makes the decision personally and of its own responsibility. In this respect, the board is responsible for the selection, the application, and the monitoring of AI use in general. The board has to provide the necessary information, must exclude conflicts of interest, and has to perform plausibility checks of the results obtained. In addition, data protection law limits and a non-discriminatory procedure must be observed. In any event, a blanket commitment, self-commitment, to the results of an AI application is incompatible with the management responsibility and the personal accountability of the board members. At all times, the applied AI must be manageable and controllable in order to make sure that no human loss of control occurs and the decision-making process is comprehensible. In order to cope with the challenges that the use of AI applications cause, the structure and composition of the management and the supervisory board has already changed quite a bit. That manifests itself in the establishment of new positions, such as a Chief Information Officer, CIO, a Chief Digital Officer, CDO. Almost half of the 30 largest German companies have such a responsibility on the board level. In addition, soft factors are becoming increasingly important in corporate management. Under the term corporate digital responsibility, CDR, it's a lot of abbreviations, I know, specific responsibilities are developing for the use of AI and other digital innovations. For example, Deutsche Telekom has enacted 9 guidelines for responsible AI in a corporate setting. SAP established an advisory board for responsible AI consisting of experts from academia, politics, and the industry. These developments, of course, have an important influence on the overall knowledge attribution in the company and the corporate group. AI and big data make information faster available and facilitate the decision-making process on the board level. Therefore, the management board must examine whether the absence of any AI application in the information gathering and decision-making process is in the best interest of a company. However, a duty to actually use AI applications only exists in exceptional cases and depends on the market standard in the respective industry. This point is closely connected with the application of the business judgment rule as a safe harbor for AI use. Under the general concept of the business judgment rule that is well renowned in many jurisdictions, a director cannot be held liable for an entrepreneurial decision if there is no conflict of interest and she had good reason to assume to act based on adequate information and for the benefit of the company. The requirement for adequate information depends significantly on the ability to gather and analyze information. Therefore, AI and big data applications are of major importance in this course. Generally speaking, board members are not liable for individual algorithmic errors as long as an algorithm works reliably, does not make unlawful decisions, there is no conflict of interest, and if AI's functioning is fundamentally overseen and properly documented. Now, ladies and gentlemen, time is almost up, and I'm going to conclude. First of all, AI is not the end of corporate law or corporate governance, as many authors predicted. Rather, AI has a potential to change the overall corporate governance system significantly. However, currently, there is no need for a strict AI regulation with a specific focus on corporations. We rather see a creeping change from corporate governance to algorithm governance that has the potential to enhance, but also the risk to destabilize the current system. What we really need is the disclosure of information about the company's practices with regard to AI application, organization, and oversight, as well as potentials and risks. Because what would help to raise their awareness and to enhance the overall algorithmic governance system would be, for that purpose, that the already mandatory corporate governance report that many jurisdictions require, such as the UK, the US, Germany, should be supplemented with additional explanations on AI, responsible AI, of course. Thank you so much for your kind attention.
Thank you very much, Professor Lierde, for your excellent presentation. And you've talked about the challenges of AI to corporate governance and also the risks and also the use of AI for corporate governance, and also given very good suggestions on the sort of, you can say, changes or amendments to the corporate governance. So later we'll come back to questions and answers part for the audience to ask further questions. Okay. So now the second presenter is Professor Oreste Pollicino from Bocconi University, Italy. So Professor Pollicino, please.
Thank you so much. I'm Giovanni Roy, and I will present for both of us since Professor Pollicino could not join us today. But of course, he apologized for this, but he have a personal reason not to do that today. And so I will present, of course, this presentation because this at the very end is a joint presentation. So let me share the screen. Can you see my presentation? Great, thank you so much. So thanks a lot. It is such a pleasure. I would say I will speak also for for Oreste is not here. It's such a pleasure for us to to present at this conference with all of you. And I mean the topic of our presentation is about the role of the rule of law, especially in times of as you know, of digital technologies, but especially from a constitutional perspective. So the big question behind this presentation is actually what is the consequences for the rule of law and the constitutional law, especially when we focus on the implementation of course, of digital technology firstly, but then also by, automated decision-making technologies and AI technologies. So it's actually a presentation showing the challenges for the rule of law, but also the opportunities and why the rule of law is in a process of digital transition, And so just starting from the very beginning, very briefly, the concept of the rule of law. There is no the need actually to focus so much probably on this concept now. But the idea of the rule of law, generally speaking, and this allows us to understand also because we can see a transition of the rule of law, is also because the rule of law is, of course, an important precondition for ensuring equal treatment, especially protection of fundamental rights. In a general way, it's a public expectation, it's a collective expectation towards public actors that they should not abuse their powers. And so, of course, it's an instrument to increase transparency and accountability of these actors. And of course, it's generally speaking, it's an instrument to manage powers, especially, and limits powers, especially public power, state power. So this is actually the general, goal of the principle of the rule of law, generally speaking. So the question is, what happens when we put the traditional challenges connected to the principle of the rule of law within the framework of the information society and the algorithmic society, or if you want to use other labels, with other challenges also for the rule of law when we focus on digital capitalism, on platform capitalism. So basically, what happens when we see this kind of transition of the rule of law from actually towards the digital environment, from the atomic reality to the digital environment? So the question is how we can frame this kind of transition. First of all, there are at least three macro clusters, let's say. Of course, since the beginning of the last century, we've seen what has been the geographical question, So the question about territory and sovereignty and the possibility that there are multiple understanding of the rule of law applying to different countries. And so, for example, the case of Yahoo Lycra at the beginning of this century has shown actually this kind of tension between the France and the US in applying standards and their law to the selling of Nazi memorabilia. And this has been, and so this is a case concerning hate speech. So this has already shown, in a way, the geographical clash between multiple definition of the rule of law, multiple legal systems. And so this is the first question where we've seen how the internet has put different jurisdiction, to connect each other and to also dialogue each other, dialogue together. But there is also another point where we can see this kind of changing in this transition of the rule of law is precisely in the delegation question. That concern that we have seen also how public actors, and this is not just something concerning digital technologies, but how public actors increasingly rely on the private sector to perform public policies online. And if you think about that, we can think about the privatization of different public services, even beyond digital technologies. If you think about for example, health services, prisons, or all these kind of public services that are increasingly privatized. So the question is, we increasingly see how there is a problem for the rule of law because it's increasingly the states rely on the private sector in order, for example, to moderate hate speech online. I don't know, for surveillance. So this is a question concerning the rule of law and how the cooperation between public and private authorities is relevant for the principle of the rule of law in the digital age, let's say that. And thirdly, there is another question. This is the technological question, and also the presentation that, of course, it has been already done in this panel, actually has anticipated this point. Of course, concern a lot about the way in which technology, especially algorithms and AI technologies, are able to set standards, to define, margins that, of course, in a way competes with the idea of the law, the idea of standards and legal rules. So the other question for the rule of law in terms of AI technology, in terms of artificial intelligence, the age of artificial intelligence, is how we can avoid that the rule of tech, the technological, rule coming from the automated decision taken by algorithmic technologies, or even as programmed by private actors, public actors, do not actually overcome the traditional protection coming from the principle of the rule of law. So these are the three, at least, macro cluster where you can see this transition from the atomic dimension to the digital environment. Once again, so we moved from a traditional framework where we think about the rule of law and the abuse of public powers to a framework where we have multiple layers of abuse coming from different understanding. And so this is what why we are focusing on the challenges of what is usually called by the Algorithmic Society, is precisely that environment, that societal environment where we have seen the increasing collaboration and interaction, not only between states and individuals, so the vertical dimension that characterize the principle of the rule of law, but also between individuals and also private actors. So we increasingly is an horizontal relationship, but this is an increasingly interesting path of evolution for constitutional law and also for the principle of the rule of law, because we know that the principle of the rule of law applies for public actors. So of course, it's a principle requiring public actors to comply with some rules, of course, unless there is not a kind of regulation, as has been already stressed in this panel, of course, requiring private actors to comply with some rules, like in the case, for example, of corporate government. But I mean, in this case, of course, we have the traditional idea of modern constitution. It is the protection of fundamental rights and the limitation of powers. That this does not just concern the state, but is increasingly concerned, in a way, private actors, and I mean, also the way in which private actors shape technological developments. And so the question for what we usually also with principle, call digital constitutionalism is to actually reframe how constitutional principles, also like the rule of law, is reframed in the algorithmic society, where we have increasingly seen and experienced this move from a vertical relationship to an horizontal relationship, to a multi-layer relationship between actors. So of course, this idea of digital constitution tries to describe what are the ideas and the principles of this new relationship, and of course, what is the role for constitutional law in this new framework, in this new technological development. And of course, just to provide you an example, because just to focus a little bit more on what we want to present in this case, is basically we can see there is a big tension when we focus on fundamental rights and democracy. There's plenty of example of how we have seen how, for example, private actors like online platforms and social media have been, of course, engine for democracy, providing also spaces for, of course, connecting and keeping social relationship and so forth. But at the same time, we've seen also how these actors have started to provide standards of protection. Think about the process of content moderation. So how some actors actually take decisions on online content. Just the example of the deplatforming of President Trump is just an example. The former President Trump is just an example. But this shows us how these actors are increasingly able to develop private standards of protection that they actually compete with the idea of the rule of law. In this case, we have a kind of competition between the rule of law and the rule of platforms. And so it's increasingly interesting to see this kind of competition, but this can also be seen, of course, in the framework of data, for instance. But the idea is that, of course, there is we should be aware of the challenges for the protection of fundamental rights and democracy when we address the problem of the rule of law in the digital age. So this is just an example. If we want to focus more, for example, on content moderation, and talking about the digital public sphere, we increasingly see the power of online platform to govern information online, and we have plenty of examples. And I've just mentioned one, but there is other examples showing how these actors are able to set their own standards to moderate speech on a global scale. But the idea is that they are not just able to set, but they are also able to enforce and balancing these rules. And this mirrors, in a way, the way in which traditional public authorities exercise their powers, if you think about that. So they are able to set rules, so the rule of law, of course, enforce these rules according to certain procedures, so the rule of law again, and balancing rights and freedoms is a role of the usually complex, or is the role of the judiciary, the role of courts. And so this is a question for, once again, and the role of digital constitution, the rule of law in the digital age push us, encourage us to think about if there is a room, for transparency and accountability. For example, in the case of content moderation, in the case of online platform function, online platform businesses, or in generally, when we focus on the idea of AI technologies. And so the question is, for example, in the case of content, can we think about the principle of the rule of law in the case of collaboration? For sure. For example, Europe is doing a lot, for example, in pushing and increasing transparency and accountability in the process of collaboration through the Digital Service Act. But still, the role of online platform in setting the standards is relevant. So it's very important just to understand these kind of challenges for the rule of law. And so what is the remedies? Also looking at digital constitution, what are the remedies that constitutional law and generally the principles can provide? Of course, as I have already mentioned, there is this kind of translation from the vertical relationship to the horizontal relationship. And this, of course, calls for looking at the horizontal effect of constitutional rights and the role of courts. So the role of courts in interpreting, also constitutional principles, but also in enforcing constitutional principles directly in the relationship between private actors is something that belongs more to the European constitutional tradition rather than to other tradition, legal tradition like the US one that is rooted in, for example, in the state action doctrine. And the other point is, the very important point is the regulating power to procedures and the role of lawmakers. So on the one hand, we have the role of courts as remedies, even as exceptional remedies, because the horizontal effects is a case-by-case remedy. But then we have, of course, the power of lawmakers to regulate these actors. And there, the problem is about, the challenge is about what are the limits of this regulation, especially on a global scope. And we have already talked a lot about the extraterritoriality or the broader scope, for example, of the GDPR, of other legislation, for example, in Europe. And this, of course, requires us thinking about what is the limits of the rule of law when the state tries to regulate, digital technologies beyond its state boundaries, territorial boundaries. And once again, we go back to one of the problems we said at the beginning. And so just to actually to close this presentation, there is still, if you want to focus on another example in context, we can see how there is increasingly a different approaches, for example, from two constitutional democracies to this problem. Indeed, the Europe, as I've already mentioned, has been to try to inject, and even the recent proposal for regulation on AI shows a kind of top-down approach and regulation of this technology. And so the idea of the rule of law in the development of these technologies. But on the other hand, when we look at the US, we see still an approach that is very much focused on digital liberalism. So the idea to leave these areas of technology developing by themselves, also through private actors, is still the core of the game. And this, of course, is pretty much the very briefly, I know, but because I have no time, but maybe we can discuss that, is much the situation that we can see how the rule of law is taught also in different ways, because of course that new relationship of horizontality that I mentioned before, that does not concern anymore, or just any longer, the relationship between state and individual, but also a relationship between other forms of private powers or other forms of private, freedoms and the individuals, for sure. So there is more a triangular relationship, as also Jack Walking usually mentioned, or also a kind of more multi-layered relationship. So this is it for my presentation. I will be more than happy, of course, to hear all of your questions. And thanks so much for listening also from Oreste. Of course, this is a kind of joint presentation. Thank you so much.
Yeah, thank you, Giovanni, very much for presenting the very interesting co-authored paper. And you've talked about essentially the public law rules and the application in the digital era, and by looking at the comparative study in Europe and UK, two different approaches. And I'm sure participants will have more questions for you later. Okay. So now the third paper is also a joint authored paper and will be presented by Professor Huijin Jiang and Professor Wen Xiaochuan. So the floor is yours.
Thank you, Chair. So I'm going to share my screen. Can you see my screen now?
Yes.
Okay, thank you.
Yes.
Thank you very much. Thank you, Chair, and thank you very much for the conference organizer to offering this opportunity to share our recent research on China's foreign investment regime in this great conference. The co-author, Professor Wong, has a conflict schedule today, so I'm going to give the presentation on his behalf here. So leveling the playing field for foreign investors, this is a principle of China's Foreign Investment Law 2020, which became effective since the January the 1st, 2020. So a year and a half have passed since the law came into force, making it a suitable time to evaluate the operation of this principle. So in the next 15 minutes, I will provide a brief analysis on the history, the present, and the future of this principle. To begin with, literature such as the World Investment Report has shown that various countries have strengthened or adopted new rules regarding to safeguard national security interests against potential threats. So this suggests a global context that discussion about investment is bound up with discussion of security and protection. So in this context, in this global context, China, however, continues to liberalize its foreign investment regime, particularly by the promulgation of the foreign investment law in 2019, which became effective last year, to further improve and optimize its business environment. So as a fundamental principle of the foreign investment law, leveling the playing field is meant to announce China's willingness to offer foreign investors equal treatment, greater market access, and better legal protection. The history is essential in anticipating China's present and future approaches to continuously strengthen the principle in practice. We consider the whole process can be divided into 3 stages. It started with the 2-track system, which was opposite with the principle, and then it gradually moved towards the principle. So with more details to be given shortly, we can see that both domestic and international factors played significant roles in pushing forward the transition. The first stage, the 2-track system. So in the initial stages of China's reform and opening up policy in 1978, China took a quite cautious attitude towards foreign investment by applying different rules or different tracks to foreign and domestic investors. This regulatory approach is normally referred to as a 2-track system, meaning different rules for different investors, the foreign investors and domestic investors. The different rules can be seen in 2 interesting aspects, like some less favorable treatment than foreign investment, than domestic investors in some aspects, and some more favorable treatment in some other aspects. So on the one hand, China accorded foreign investment less favorable treatment than domestic investors by applying the famous 3 FIE law, the laws applying to 3 types of foreign invested entities, namely the Chinese foreign joint venture, the Chinese foreign contractual joint venture, the Chinese foreign equity joint venture, and the wholly foreign owned enterprises. So under these 3 FIE laws and respective regulations, foreign investment activities was subject to strict government review, in that all proposed investment are subject to review regardless of the sectors, regardless of the amount of investment. The approvals are needed in the establishment, the modification, and the termination of foreign investments. Therefore, this two-track system, or this all subject to review system, imposes additional approval requirements on foreign invested entities in comparison with those imposed on domestic entities. Also, the less favorable treatment can be seen in the performance requirements on foreign invested entities, such as the local content requirements, the trade balancing requirements, and export restrictions. As an example, the local content requirements. So under the same conditions, the material needed shall give priority to purchase in the Chinese, the domestic market. That is a local content requirement. So these are the two aspects that foreign invested entities enjoyed less favorable treatment than domestic entities. So on the other hand, in order to pursue a proper balance between encouraging foreign investment and maintaining regulatory control over foreign investment, China provided foreign invested entities tax preferences, such as tax holidays and tax reductions, in order to attract foreign investment. So these tax preferences were not enjoyed by domestic investors. So we can see under this two-track system, it is obvious that the playing field for foreign and domestic investors were not leveled. When China was continuing to recover its GATT position and later to accede to the WTO, it took several steps to conform with the WTO rules, so resulting in a more leveled playing field. So the impact of the WTO regime on China's foreign investment regime is very important. For instance, transparency. Transparency is a critical principle of the WTO. So in order to increase the transparency of China's foreign investment regime, in 1995, it issued the catalog for the guidelines of foreign investment, which clarified the industries that are open or closed to foreign investment to increase the transparency. And to the other part, like the market access and national treatment, to implement China's commitment in terms of market access and national treatment in service trade under the GATS and service schedule, it revised the catalog for several times. For instance, in 2002, the catalog added 24 sectors according to its WTO commitment that are open to foreign investment. Third, the impact of WTO is that the 3 FIE laws I've just mentioned were revised by removing the performance requirements in order to fully comply with China's commitment under the TRIPS agreement. So the last approach adopted in this stage is the unification of the tax regime. China unified the tax regime in this stage in order to establish a socialist market economy. So as just mentioned, the tax preferences regime was inconsistent with the fair competition requirements required by the socialist market economy, because domestic entities were not competing with foreign invested entities on a leveled playing field. So all the taxes were unified in this stage. As a significant move was the issuance of the enterprise income tax law in 2007, which replaces the previous separate income tax laws for domestic and foreign investors. To note, sorry, it does not mean that foreign invested entities cannot enjoy any tax reductions, but it means that they cannot enjoy more favorable tax reductions than domestic entities. For instance, for high-tech and new tech enterprises and for agriculture businesses, a reduced tax rate will apply. So of course, the tax preferences in this stage echoed China's industry policies, such as to development, agriculture, and high-tech industries. Then we move to the third stage. So starting in 2013, so in the context of the fifth round of China-US strategic and economic dialogue, China and also in the background of China's domestic policies, such as to further deepen its opening up policy and to reform its administrative to simplify its administrative process. In 2013, China started to pilot the pre-entry national treatment and negative list approach in the Shanghai pilot free trade zone and later in more free trade zones. So this is very important because this means that approvals are needed only for foreign investment in sectors on the negative list. So the all subject to approval requirement was mostly removed. So initially, the negative list for the free trade zones was very long, but now there are only 30 sectors. Based on the successful experience of Shanghai and other free trade zones, China amended its 3 FIE laws in 2016 by implementing the national treatment plus negative list approach and issued the nationwide negative list in 2018. So far, we can see the playing field is much leveled by the unification of taxation and the application of the negative list approach. The principle today, so the foreign investment law mainly provide the kind of the guidelines in applying the principle. For instance, the foreign investors and domestic investors, they will enjoy equal treatment during the setting up stage, after they were established, and if they would like to remit from China. But as we can see from the slide, all these rules or these articles in the foreign investment law are very general and lacks the substance. Therefore, what has been done in later is to provide the details in the following regulations and rules. For instance, the regulation for implementing the FIL, the Foreign Investment Law Regulation, which set out detailed rules on the implementation of the principle. For instance, the Foreign Investment Law provides that supporting policies will apply equally to foreign and domestic investors, and the regulation provide more details by detailing the types of supporting policies, such as government funding arrangement, the tax and fee reduction and the exemption, and so on. As a vivid example is that China applies same tax reductions to both domestic and foreign entities equally due to the impact of the COVID-19. The negative list 2020 has further reduced and so on. China has also abolished many rules regarding the foreign investment regulation. Although the playing field for foreign invested entities and domestic entities are leveled today, suggesting China's significant liberalization of its foreign investment regime, we cannot omit the exceptions to the principle. So the exceptions we can see, the first is the negative list, of course. The negative lists are not going to be reduced to zero. This is also consistent with international rules. For instance, defense-related industries are on the list. And second, the national security review system for foreign investment. But as evidenced by the empirical experience, as we can see in practice, China rarely used this national security review system to block transaction. So what is going to be done in the future? So we, based on the previous discussion analysis, we can reach two main findings. First is that both the domestic and international factors have influenced the development and the implementation of the principle. The domestic factors, such as the opening up policy, the socialist market economy, the international factors, such as the WTO regime, and also the strategic and economic dialogue with the US, they all make contributions. And in the context of China concluded RCEP last year and its active and favorable consideration of joining the CPTPP, China's future environment will continue to be liberalized and improved. But we can see, although many rules have been issued in the last year, in the last 2 years, still some details are still lacking. Therefore, in the next step is to clean up existing rules inconsistent with the principle and to ensure new rules on implementing the principle. So due to the time limit, I'm not going to list the details of the future work. So to conclude, the authors consider that China will continue to implement the principle of leveling the playing field, and it will continue to liberalize its foreign investment regime and optimize the legal environment for foreign investors and their investment. So that's all, and thank you very much for your attention. Comments and questions are more than welcomed. Thank you.
Thank you, Professor Zhang, for your detailed discussion of how China has moved through the 3 stages and to implement the principle, and also the reasons for such a change or moving towards the principle and the future development. So now the floor is open for questions for all the 3 presentations. Okay. And here on the Q&A section here, we have 2 questions. Okay. One is to Professor Lieda. So the question is, do you think AI can replace corporate boards someday in the future when strong AI is available?
Yeah, this is quite an interesting question. First of all, there are some authors that argue that boards will be replaced by AI. For example, Armer and Eidenmüller, they argue that we have something like self-driving companies, like self-driving cars and self-driving companies. It's like, basically the same thing. That would mean that there is no longer a human being in charge of running the corporation. It's only a strong AI, and all we see inside the corporation are shareholders. The shareholders as the residual persons interested. They give money and they get a revenue, a dividend out of the corporations. There's a problem with that idea of self-driving companies, as under my guidelines that I developed how to apply AI. One of my points was that AI needs to be manageable and controllable. This is just like having a missile or a weapon of mass destruction. It's always important to have like the exit pin, that you can cancel something like that. So let me put it another way. If we have a strong AI, then the question of having AI in the boardroom is not the most important question at all, as we have to find a way to deal with a strong AI. That means that is a strong AI that is conscious of itself. This is like we are closing contracts with an AI. We have perhaps a regime or a system of AI, you know, I don't want to go into science fiction stuff, like, you know, you're trying to pull the plug and you get a stroke from the machine. You know, this is science fiction, but you know, we need to make sure that in any event, having AI or having AI applications, we need a human being in control, and we need to have a human being in control also when we have a strong AI with regard to the boardroom. So the question would be, I don't think so.
Right, okay, thank you. So the second question is, how do we empower small-scale businesses that might not be aware of the rule of law and its application? So the question may be to you and also to Giovanni, I guess. So
I would go to give the floor to Giovanni. I think it's a question for him.
All right, Giovanni.
Thank you.
Yeah.
I mean, it's a very good question. It's not easy to answer because I would like also to continue from what Jan has already said. I mean, on the control, if you agree with that, the control for human beings, you know, in the field of AI and the rule of law. I mean, that is a really important question and discussion, and it's not. There are also legal instruments in a way pushing for that. It's a very important point. And we also seen, for example, I mean, there is a huge discussion, for example, on Article 22 of the GDPR, that it concerns just personal data. But definitely the role and the other safeguards, even there is not just human safeguards, are really important in the field of AI, also for the future. I mean, the point is what the and this just I would like just to say this very small future, then we can continue with the question. I mean, the point is what is really the role of humans in this case, you know, because no one's really understand. I mean, not really understand, but we have some ideas, you know, on what a human could do, maybe revise certain decisions, or I don't know, maybe say yes or not. So there are different ways in which we can imagine the role of human in the loop. Maybe we should think more, because we say usually that there should be a human in the field of AI. So when there is a decision taken by AI, but the question, in my opinion, is what is also how we can find a scalable model where humans can intervene, you know, effectively. I mean, and this of course depends on a case-by-case situation, just so it not be a general model, you know. But generally speaking, I think that you should think about what kind of help, you know, a human can provide. Maybe can review the decision. He can just say, no, the decision is not important. I just review by scratch, you know. So we should think about more about this thing, maybe with a multi-layer approach, depending on the case, even on the risk concerning a certain technology. And sorry if I decide to get back to this point, but I think it's really, really important even for discussion. So the risk-based assessment and the role of humans in this technology is very much connected to the rule of law.
Okay, thank you, Giovanni. So are there any other questions? We still have a few minutes for this session.
I think I can I share a broad question in common, generally speaking, you know, just for all of us, just if you want to, you know, also to answer. So my question is, generally speaking, at the intersection between all the presentations that show very different ways in which the rule of law, you know, generally this technology can challenge, you know, the traditional way or the traditional way in which legal frameworks are created, even in different sectors, you know. The question maybe just I would like even to hear from the other speakers, or even from the attendees, if anyone wants to answer, is how do you see, you know, also, for example, some approaches, for example, how do you see regulation in this field, especially how do you see, for example, the move of the European Union as something that could, you know, provide an horizontal framework applying to all the different sectors that we discussed? Because of course, if we have, I don't know, rules on how, you know, to set AI, what is the oversight or what should be the procedure. Of course, this impact no matter which sector we want to focus on, because this technology should be you know, designed a certain way and then applied in very different frameworks. So the question is, how do you see this approach concerning, and how do you think it would affect, you know, the legal framework you discussed, you know, even in my case, for example? And what do you think, whether there could be other, maybe at the moment, you know, there could be other examples in a comparative way, looking at other states regulating the AI, or maybe not, you know? So this is a general question just to discuss with you.
Okay, so who wants to make Professor Leda?
Yes, you know, I think this is the question. You know, this is what it's at the very core of these issues. And I think that it will be very hard to have a one size fits all approach. So, you know, if we go from, you know, the presentation on word processing algorithms, I think, you know, this is something like it's a something that is useful, you know, from the outset. If we look at weapons of mass destruction, this is the other side of the spectrum. So I think we need to focus on what are we talking about. All what I've said with regard to corporate law, you know, I'm a civil law guy, I'm corporate law guy. So those regulation of AI, I think this is kind of public law. This is not only legal. So we need to talk to each other, lawyers, computer scientists, and we need to make sure that we have someone or an organization that is responsible for that. So and when I say we don't need a regulation today, no strict regulation for AI in a corporate setting, then it means that we only so the board of directors, they use AI, but we need to make sure that AI applications are kind of safe, you know, like if you buy a car, this car needs to fit certain minimum requirements, and the same is true with AI. And I think, you know, the European or on the European level, we make progress, you know, with the regulation that is going on there. But I think, you know, we will see, I think, different measures, different standards for different kinds of AI with regard to different industries and use cases. So I think, you know, it's always the case that somewhat, you know, we need a certain application. You know, there's somewhat like word processing or word processing, or picture, you know, AI that works with visual stuff, like in medicine, you know, where you can detect cancer, for example. You know, this AI in this context is very advanced. I have had a presentation only last week, by a colleague in Freiburg who is working at the border of computer science and medicine. A new chair that has been handed over, whatever. So and it's amazing what we can do in this context. So you know, comparing all those use cases with each other, I think this is very difficult. So yeah, general rule, yes, but a lot of different experts for those fields. Thank you.
Okay. Thank you very much. So time is almost up. So I would like to thank all the panelists for your excellent presentations, and also thank the participants for your good questions. So now I will hand the floor to Professor Yuan Li, one of the founding co-director of APELIA, to give her closing remarks.
Thank you, Professor Lin. That was a very interesting session and very diverse as well, Jan. I remember your comments, and we will have to continue our discussions.